The court will note the appearance of Ms. Payson on behalf of the plaintiff, Mr. Sebastian on behalf of defendant, and Mr. Magnuson on behalf of the front of the court. This matter is before the court on the defendant's objection to the referee order. Mr. Sebastian.
Thank you very much, Your Honor, and good morning. Your Honor, my client was not present for that hearing, and he was in jail. There's another, for some, at least for some of the periods that are covered under the proposed recommendation. He also never received notice of the hearing. There was a no contact order as part of a domestic violence case. So it may have gone to the mailing may have gone to his home, but he didn't receive it. Be all that as it may, we still wanted to file objections if the recommendation wasn't improper. He's unemployed. Everyone apparently knew that at the hearing because the Michigan Unemployment Commission listed as his employer in the proposed order. For some reason, however, he was imputed some significant amount of income that he's never made. When he was working, he was making approximately $21,000 an hour. That would work out to about $42,000 annually. So I don't know where the number came from to try to impute that level of income to him because he doesn't have it. He lost his job because of the domestic violence action and having to go to jail and things of that nature. So there's not even a basis for an imputation under the Michigan Child Support Formula Manual 2.01G to the extent he's incarcerated. So we think that we would submit to the court that the recommended order is filled with errors and it should be recalculated based on his unemployment income, at least until he obtains employment.
Okay. Ms. Payson, what's your response?
Your Honor, I would disagree with Attorney Sebastian's statements of the facts. On July 5th of 2023, Mr. Gert was not incarcerated at the time. It was my understanding he was incarcerated on 6/24 from a domestic violence, and then later on July 13th for 1 day due to a bond condition. It was also my understanding that he did not lose any employment till mid-July or later July.
Ms. Payson, I'm sorry, I've lost the audio.
Can everyone else hear me?
I can hear you.
Yes.
Oh, there it is. I got it back. I'm sorry.
It's all right. Do you want me to start over?
If
Go
you
ahead.
wouldn't mind, please.
Okay. We disagree with the statements made by Attorney Sebastian due to the fact that the W-2 from last year by Mr. Gert was approximately $59,000, not as Mr. Gert is indicated here today. He was incarcerated for 1 day, as my understanding, on 6/24, and then he was incarcerated for 1 day again on July 13th for a bond condition. We had a hearing on July 5th of 2023, and at that point in time, it was my understanding as well as my client's understanding that Mr. Gert was still employed. My client did learn that he may have been terminated from his employment mid-July or end of July of 2023. We do believe that imputation is appropriate in this case. His own actions are what ended him to be incarcerated for a very short period of time. We don't know if he's out looking for employment. I do believe that this matter should be set probably for an evidentiary hearing to impute income to Mr. Gert. In addition to that, he does have a duty to support his children. He has not seen his children in a substantial period of time, meaning that my client has been solely responsible for meeting all of the needs of these minor children and is in need of assistance. My client also learned that as of August 5th of 2023, Mr. Gert cashed in his 401k and received about $18,000, which he is in violation of a different order, but does have funds to pay for his child support. So we would ask that this court not set aside the Uniform Child Support Order.
Okay, Mr. Magnuson.
Your Honor, I would agree with Attorney Payson. The other thing I want to make the court aware of is that we did serve him properly with notice of this hearing. And as has been indicated, he did not appear. I believe what the referee did was appropriate based on the information that we had. If you take a look at his answer, all he really tells us as far as his income goes is that it varies. He doesn't get into any more detail than that, and he wasn't at the hearing to provide any more detail. If he were, then we would have used the income of each party based on the testimony. But when he doesn't appear, there's not a lot the referee can do. So I would ask that the order stay in place. Obviously, an evidentiary hearing would be appropriate as we go forward.
Okay. Well, what the court's going to do is, obviously, there are some issues, and the court is not going to vacate the order at this time. The court will refer the matter back to the referee for further evidentiary hearing as it relates to the issue of imputation and any correction of the, again, any correction of the income amount, but the order will stand at this point, and we will address it following that referee hearing. So that will be the order of the court. We'll end this matter at 9:18 a.m. You're free to go. Have a good day.
Thank you
Thank
very
you,
much,
Your
Your
Honor.
Honor.
Thank you, Your Honor.